Keep Law Unit 2, the Law of Tort. Welcome back everybody, and today we're doing the topic negligence. So negligence is defined as the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. This was taken from the case of Blyth and Birmingham Waterworks Co Alderson. Alright, as per usual, all cases will be in the description. So another definition of negligence is the breach of a legal duty to take care which results in damage undesired by the defendant to the claimant. So in order to prove that negligence exists, there are certain situations that must be present. So there must be a duty of care owed, there must be a breach of that duty, there must be causation of loss or damage, and the damage or loss must not be too remote. So the duty of care must be owed initially. So the principle of duty of care came from Lord Atkin in the case Donoghue and Stevenson, and in this case he stated that one must take reasonable care to avoid acts or omissions which you can reasonably foresee would likely injure your neighbor. So you might ask the question then, well, in law, who is my neighbor? And essentially a neighbor is a person who you are so closely who is so closely or directly affected by your acts that you ought to reasonably have them in your contemplation as being so affected when you are directing your mind to certain acts or omissions that are relative to the given situation. So in this Donoghue and Stevenson case, the plaintiff and his friend went to a cafe, and the friend ordered a bottle of ginger beer for the plaintiff. Now the beer, which had been manufactured by the defendant, was supplied in an opaque glass bottle, which made it impossible to see the contents. The plaintiff consumed part of the beer and claimed that when she poured the rest into the glass, she was confronted, or she saw, the decomposed remains of a snail. She claimed that this sight and the beer which she had already drunk rendered her ill, and she sued the defendants in tort. And in this case, the court held that the manufacturer owed to the plaintiff a duty of care. And in the years following the Donoghue case, which established what is commonly referred to as the neighborhood principle or the neighborhood test, they tried to really establish what the test might be. So in Anns and Mertons, Lord Wilberforce stated that in order to establish that a duty of care arises in a particular situation, the question has to be approached in two stages. First, one has to ask whether, as between the alleged wrongdoer and the person who has suffered damage, is there a sufficient relationship of proximity or neighborhood, such that in the reasonable contemplation of the former, carelessness on his part may be likely to cause damage to the latter, in which case a prima facie duty of care exists. Secondly, if the question is answered affirmatively, it is necessary to consider whether there are considerations which ought to negative or reduce or limit the scope of the duty or class of persons to whom it is owed, or the damages to which a breach of it may give rise. Now this case, Anns and Mertons, led to an increase in claims in the tort of negligence, and the court found itself faced with a number of claims in new areas. The case of Murphy and Brentwood overruled Ans. In this case, the defendant, local authority, failed to inspect the foundations of a building adequately, with the result that the building became dangerously unstable. The claimant, being unable to raise any money for repairs, had to sell the house at a considerable loss, which he sought to recover from the local authority. The action failed as the loss was identified as a pure economic loss. The House of Lords overruled Ans and held that the council was not liable in the absence of physical injury. The court in Murphy favored an incremental approach to the establishment of a duty of care, and this incremental approach was stated in the case of Carparo and Dickman. In Carparo and Dickman, the court established a 3-stage test to determine whether a duty of care was owed. And this 3-stage test comprised of a reasonable foreseeability, proximity, and whether it was fair, just, and reasonable to impose such a duty. So with reasonable foreseeability, this principle states that a reasonable man in all the circumstances would see the consequences of the defendant's action. In Bourhill and Young, a woman suffered psychiatric injury, which is sometimes referred to as a nervous shock, from witnessing an accident in which the negligent rider of a motorcycle was killed. She sued his estate in negligence, arguing that the motorist had a duty of care to avoid exposing bystanders to the horrors of a fatal accident. Her claim failed. The House of Lords stated that a motorist had a right to expect that bystanders are people of reasonable fortitude and will be able to cope with the ordinary day-to-day horrors of the road. Now, this did not preclude the possibility of recovering compensation for witnessing extraordinary horrific events, but even then, of course, that would be difficult. Proximity. This refers to legal proximity. In Watson and British Boxing Board, the Boxing Board failed to provide sufficient medical care at ringside. A boxer suffered severe brain damage following an injury in the ring, but the evidence suggested that his injuries would have been less severe had better medical attention been available at the ringside. It was held that the sport's controlling body owed a duty of care to those who took part. Injury was foreseeable. The licensing system created proximity, and in all circumstances was just, fair, and reasonable to impose such a duty. The duty alleged was not a duty to take care to avoid causing personal injury, but rather a duty to take reasonable care to ensure that personal injuries already sustained were properly treated. And fair, just, and reasonable. A duty would only arise where the court says it is just, fair, and reasonable to do so. So in Barrett and Ministry of Defence, a sailor died after he choked on his own vomit as a result of his drunkenness. His wife sued the Navy, and the trial judge found in her favor. The Ministry of Defence appealed, and it was held that it was not fair, just, and reasonable to impose a duty of care in such a situation. The Court of Appeal acknowledged that there was foreseeability and proximity, but it would not be fair, just, and reasonable to impose a duty of care. It was reasonable for the law to expect an adult to take responsibility for his drinking habit. So now we're going on with the breach of duty of care. So in order to succeed in negligence, not only do you have to prove a duty of care is owed, but you must also show that the duty has been breached. A number of factors have to be taken in consideration in determining a breach of duty. So we're going to be dealing with 4 factors that must be considered. And this is the objective standard. So 1, a reasonable assessment of the risk. 2, the object to be achieved. 3, practicability of precautions. And 4, general and approved practice. So reasonable assessment of risk. This refers to both the likelihood of the harm and the seriousness of the harm that may occur. A reasonable man is not usually expected to take precautions against something where there is only a small risk of it occurring. So in Bolton v Stone, a cricket ball hit a passerby in a nearby lane. It was only 7th time in 28 years that the ball was hit out of the ground. The court ruled that since the occurrence was so rare, it was not reasonable to expect the defendant to take precautions. In Mouser and De Nobrega, the plaintiff was a spectator at a race meeting in Trinidad. A riderless horse left the racetrack at a point where there were no outer rail or fence and struck and injured the plaintiff. She brought an action against the defendants, the organizers of the race meeting. The defense was that she consented to take the risk, or voluntary non-fit injury. It was held, applying the test in Bolton, that the plaintiff was a person to whom a duty of care was owed. There was a real risk of injury to spectators at the event of a horse galloping off the track, and the defendants were negligent in having failed to take sufficient precautions to protect the plaintiff and other spectators. The defense of voluntary non-fit injury did not apply. Seriousness of the harm that may occur. So where, however, the risk is small, but the potential for harm is great, the reasonable man is expected to take precautions. And this was stated in the case of Paris and Stepney. In this case, a local authority employed Mr. Paris as a garage mechanic. Mr. Paris had lost the sight of one eye during the war. In order to loosen a stiff bolt, he struck it with a hammer. A piece of metal flew off, and because he was not wearing goggles, struck him in his good eye, causing him to be totally blind. After the accident, Mr. Paris successfully claimed damages for his injury, but this was overturned on appeal. Mr. Paris then appealed to the House of Lords. The House of Lords held that there was a breach of duty. The employer should have provided goggles to the claimant because of the seriousness of the harm to him would have been greater than that experienced by workers with sight in both eyes. The duty is owed to the particular claimant and not to a class of persons of reasonable workers. Very important to note. The duty is owed to the particular claimant, not to a class of persons of reasonable workers. Objectives to be achieved. This is the second category. Now, the importance of the objective to be achieved is also a factor which is taken into account when deciding whether the defendant has breached the duty of care. So in the case of Watt and Hertfordshire, the claimant, who was a fireman, sued his employers in negligence when he was injured by a heavy jack that had not been properly secured on his vehicle whilst attending an emergency call. It was held that the employer did owe the fireman a duty of care, whether it had been a breach of duty depending on whether it behaved reasonably in the circumstances. In this case, the circumstances were that the fire engine was being prepared for an emergency call, and it was not unreasonable that less attention was paid to matters of storage than would have been appropriate in other situations. It is also important and necessary to examine the utility of the defendant's act. So in the case of Robley and Placide, the appellant was a leader of a party of police constables who went to the compound of the General Hospital to investigate a report of violence. They saw a number of men armed with cutlasses come out from one of the buildings. They gave chase, and the appellant and another constable eventually caught up with the men, who turned around and began to advance menacingly towards the appellant. When they were at a distance of about 20 to 25 feet from the appellant, he aimed his pistol at one of the men and fired a shot. The shot missed the man, but struck the respondent, a pedestrian, in her leg. The trial judge held that the appellant was liable to the respondent in negligence. The defendants appealed. On appeal, it was held that no legal duty to retreat could arise in circumstances where a police officer acted in the execution of his statutory duty to arrest persons who were prima facie committing, within his view, the offence of being armed with offensive weapons. The necessity of saving life and limb justified the appellant in taking the risk of the possible injury to the respondent. The appellant was therefore not liable in negligence. The practicality of precautions. Which is number 3, the third factor. The cost of avoiding a risk is a material factor in assessing standard of care. The defendant will not be expected to spend vast sums of money on avoiding a risk which is very small. This was held in the case of Latimer and AEC Limited. Plaintiff was employed by the defendant. On the afternoon of the day of the accident, an exceptionally heavy rainstorm had flooded the whole of the defendant's premises. Oil, which normally ran in covered channels in the floor of the building, rose to the surface, and when the water drained away, left an oily film on the floor. The defendants took measures to clean away the oil, using all the sawdust available to them. The plaintiff came on duty with the night shift, unaware of the condition of the floor. While endeavoring to place a heavy barrel on a trolley, his foot slipped on the still oily surface, and he fell on his back, and the barrel crushed his left ankle. The trial judge found a breach of common law duty. The defendant appealed the decision, and on appeal it was held that the reasonable employer had to make a decision whether or not to shut the factory down and totally eliminate the risk. The employer took every step that reasonably could have been taken in the circumstances, and in doing so had avoided the argument of negligence. A defendant does not have to totally eliminate the risk, but must do as much as reasonably possible, or as much as the reasonable person would do in these circumstances. I'll repeat that: a defendant does not have to totally eliminate the risk, but must do as much as the reasonable person or as reasonably possible in the circumstances. General and approved practices. This is the fourth factor. Now it is shown, or if it is shown rather, that the defendant acted in accordance with general and approved practices, then it may be concluded that he is not negligent. So in the case of Bolam and Friern Hospital Management Committee, the plaintiff, who was suffering from a mental illness, consented to electroconvulsive therapy, resulting in him suffering several fractures. He thereafter claimed damages against the hospital, claiming that the treatment he had been administered was incorrectly done so, and that he had not been advised of the risk. The case held that 1. A doctor is not negligent if he is acting in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular act. Secondly, the doctor could not be criticized if, believing the dangers involved in the treatment to be minimal, he did not stress them to the patient. 3. In order to recover damages for failing to give warning, the plaintiff must show not only that the failure to warn about the risk was negligent, but also that if he had been warned, he would not have consented to the treatment. It should be noted, however, that the general and approved practices must not obviate folly. The court stated that neglect of duty does not by repetition cause or cease to be neglect of duty. I repeat that: neglect of duty does not by repetition cease to be neglect of duty. So now we're moving on to other skilled defendants. So skilled defendants are judged by their standards of the ordinary skilled person exercising the same skill. Interestingly, however, a young, inexperienced doctor will be judged by the standard of a competent, experienced doctor. A lone driver will be judged by the standard of a competent, experienced driver. A householder providing or performing a do-it-yourself task at home will be judged by the standard of a reasonably competent carpenter. That is important to note. So on the topic of res ispa loquitur, in some situations the plaintiff will not need to prove a breach of duty of care. It's important to note that in some cases the plaintiff will not need to prove a breach of duty of care. When these situations arise, it is known as res ispa loquitur, which means that the thing speaks for itself. Res ispa loquitur would apply in the following circumstances. 1. The thing is under the control of the defendant. 2. The defendant has knowledge denied to the plaintiff. And 3. The damage is such that it would not normally happen if proper care had been shown. If these requirements are fulfilled, there is a prima facie evidence of a breach of duty. The burden of proof is then shifted to the defendant, who must prove that he showed reasonable care. It must be remembered that the maxim does not apply when the facts are sufficiently known, because it depends on an absence of explanation. In Friern and Boadle, a barrel of flour fell from the defendant's warehouse, injuring the plaintiff, who was a passerby. No explanation was given by the defendant for the incident, and the plaintiff was in no position to prove a breach of duty by the defendant. The court then put the burden of proof on the defendant to show that he had not broken his duty of care, and he failed to show this, and as a result, the plaintiff was successful. In Fish and Kapur, the plaintiff's jaw was broken after the defendant, a dentist, had extracted a tooth. It was held that this was not a res ex loquitur situation. There were reasons other than the dentist's breach of duty which could have accounted for his broken jaw. One example was that the plaintiff may have had a weak jaw. The plaintiff was therefore forced to prove the requirements of negligence in the usual manner. Traffic accidents. The doctrine of res ex loquitur is often used in cases of traffic accidents. A driver is under a duty to take care not to cause damage to all road users, including pedestrians. The driver is therefore under an obligation to do all that he can do for example, avoid drinking, using drugs, obeying the law, anything to avoid accidents. Once the accident occurs, the plaintiff relies on res ex loquitur. He must then prove the following. He must prove that 1. The thing causing the damage was under the control of the defendant, and secondly, in the ordinary course of things, the accident would not have happened without negligence. Once the plaintiff has established these facts, a presumption of negligence has been created. The onus will now be on the defendant to rebut this presumption. So in the case of Omnibus Services Limited and Hamilton, the plaintiff was a passenger in one of the defendant's buses, when he was thrown from his seat after the emergency door of the bus suddenly opened. The plaintiff was only 9 years old at the time and sustained injuries. The plaintiff relied on res ex loquitur, and as such, a presumption of negligence was created. The defendant argued that they did not have control over the door, as it was possible for passengers to do damage to the door. The defense relied on a case of the House of Lords, in which the court ruled that the doors of a train were not continuously under the sole control of the railway company. However, in this case, they held that the defendant was liable. The court distinguished this case from the House of Lords decision and found that in this case, the defendant was in control of the emergency door, which gave rise to a presumption of negligence, which was not rebutted by the defendant. Now, the House of Lords case that was sought to be used by the defendant in the aforementioned case of Omnibus and Hamilton was the case of Esson and London and North Eastern Railway. In this case, a 4-year-old boy fell through the door of a corridor train, and in this case they held that the door was not under the sole control of the defendant, as other persons had control over the door. The court added that people were walking up and down the corridor during the journey, so it was not unreasonable to expect the officers to detect immediately that a passenger interfered with the door. It was not reasonable, to expect the officers to detect that the door was interfered with. Defenses against traffic accidents using res ex loquitur. Skids. It will not be enough for the defendant to argue that his vehicle skidded. In Parero and Co, A 14-year-old boy was killed when he was struck by a car which skidded on a wet road and mounted a pavement. Res Isper locator was raised against the driver. The defendant raised the issue of the skid and argued that because the car skidded, he cannot be held liable. It was held that the prima facie case of negligence is not rebutted by merely showing that the car skidded. The defendant must show that the skid occurred without any negligence on his part. However, it is possible to rebut the presumption of negligence, and in the case of McCacree and Achille provides an example. The defendant's car skidded diagonally across the road and hit a parked car immediately behind the plaintiff's car, pushing it into plaintiff's car and causing damage. The defendant argued that he ran into a patch of oil on the surface of the road, which caused his car to skid. In this case, it was held a presumption of negligence has been created. Under normal circumstances, a car will not leave its proper side of the road and run into another vehicle on the other side of the road. This presumption is, however, rebutted with evidence that the defendant was not driving with excessive speed before coming into contact with the oil, so the presumption can be rebutted. Tire burst, another defense. The defendant must show, however, in relying on this defense, that more than the fact that the tire burst. So in Smith and Company, Williams Construction Limited held that that presumption cannot be rebutted by the fact that the tire alone burst, but the defendant must show that he had a system of examination and inspection of his tires, so that he must show that he didn't allow it to run to the point where it was bare and thin, but that he would constantly examine and inspect his tires to ensure that they met the road standards. So now, we're moving on to causation. And the claimant has to prove not only that the defendant owes him a duty of care and has breached his duty, but he also has to prove that the defendant's breach caused his loss. Causation would be looked at from a number of possible situations, and these are single causes, several successive causes, simultaneous events, several possible causes. Let me just deal with these four for the purposes of this video. So single cause. When there's only one possible cause of the claimant's loss, a but-for test is applied. And essentially what a but-for test is, it is the question of, but for the defendant's action, would the claimant have suffered any loss? If the action is yes, the claimant would lose his case. If however the answer is no, the claimant would win his case. And so but for the defendant's action, would the claimant have suffered loss? Right, so in Barnett and Chelsea and Kensington Hotel Management, the but-for test was applied. So in this case, a night watchman called a hospital at the end of a shift complaining of vomiting after drinking tea. The nurse consulted a doctor by telephone, and he advised that they should go home and consult their doctor in the morning. The claimant's husband died that same morning from arsenic poisoning. It was clear that the doctor owed a duty of care, and he breached that duty by not coming to see the claimant. When the court applied the but-for test, however, the hospital was not liable, as it was found that even if the doctor examined the plaintiff, he would have still died, as at the time there was no effective treatment available. So several successive causes. The but-for test is not very effective when dealing with several successive causes of a particular situation. So the court therefore has to make a proper judgment in these cases. And the court ruled that where there is a tortious second event, the court has to decide which cause is operative. If the later event has not added to the claimant's damage, the person who caused the original damage is still liable. So in Baker and Willoughby, the court found that the defendant liable even where a successive event worsened the plaintiff's situation. So the defendant had injured the plaintiff's leg, and before trial the plaintiff was working on a new job where he was the victim of an armed robbery. The injured leg had to be removed after he was shot in the robbery. The court, however, ruled that the defendant was liable for the loss of the plaintiff's leg. The fact that it was damaged at some later date did not alter the fact that he had already been deprived of a perfectly good leg. If the robbers had been found, they would have been responsible only for the additional loss they inflicted. Similarly, in Jobling and associated dairies, the court reached a different decision. So not similarly, but it's the same principle. In the year 1973, the plaintiff had suffered a back injury as a result of the defendant's negligence, which reduced his earning capacity by 50%. In 1976, he was found to be suffering from a disease unrelated to his accident, which prevented him from working altogether. The court, however, ruled that the defendant was only liable for his reduced earning capacity between 1973 and 1976. And this case was differentiated from Baker because of the successive events, which were non-tortious. Thirdly, several possible causes. Now there can be several possible causes for an injury. That makes sense, right? And the courts in dealing with these cases initially took the approach in McGee and National Coal Board. And in this case, the plaintiff got dermatitis, and his defendant failed to supply washing facilities. It was not proven that the supply of washing facilities caused the injury. However, the plaintiff won because the court said that the defendant's breach materially increased the risk to the plaintiff. In recent times, the court has taken the approach to say that for the defendant to be liable, the defendant's action must be the probable cause. And this reasoning was used in Wiltshire and Essex. Additionally, in Fairchild and Glevenhaven Funeral Services, this was also applied. So the plaintiff or the plaintiffs were a group of workers and exposed themselves to asbestos in successive periods of employment. Now, the defendant was a group of employers, and it could not be proven exactly which employer and when the incident took place, which employer was in charge. So the court ruled that the increased risk by all the defendants caused the injury and that they were jointly liable for the damage suffered. Now, moving on to remoteness of damage. And the concept of remoteness of damage is one way in which the law sets limits to the extent of a defendant's liability for the consequences of his negligence. The basic rule is that a defendant will only be liable for those consequences of his negligent act which are not too remote in law, even though such an act may be said on the application of the but-for test to have caused the negligence complained of. Now, issues of remoteness arise where the consequences could not have been foreseen. The harm which was foreseeable was a different kind, or of a different kind. There was a pre-existing condition, and there was a new act intervening that actually caused the damage, or where the loss was purely economic. There are competing tests for remoteness of damage. One is the direct consequences test, and the second one is the reasonable foreseeability test. So the test for remoteness, direct consequences test. This was taken from re Polymis, which is a case, and in this case the defendant chartered a ship and had loaded it with petrol. Now the ship encountered bad weather and the petrol leaked, and while docked at Casablanca, the defendant's workers carelessly allowed a plank to fall into the hull of the ship. The falling plank struck something and thereby caused a spark, which in turn ignited the petrol vapor in the hold. The vapor caused a fire which destroyed the entire ship. It was held that the fire was not a reasonably foreseeable consequence of allowing a plank to fall. However, it was reasonably foreseeable that the falling plank would cause some form of damage to the vessel. Because of this, the court established the defendant's negligence. So, whether the particular damage caused by the fire was recoverable depended solely on it being a direct consequence of the negligent act. All the damage by the fire could not have reasonably been foreseen as a consequence of dropping the plan. The defendant was therefore liable for the loss of the ship by fire. Reasonably foreseeability test, the second test. This was used in the case of Wagon Mound. So in this case, the defendant had discharged oil from their ship, the Wagon Mound, into the Sydney harbour. The wind and tide carried the oil beneath the claimant's or the plaintiff's wharf, where welding operations were being carried on by the claimant's employees. After being advised that they could safely weld, the claimant's employees continued their work. Some 55 to 60 hours after the originating discharge, molten metal set some waste floating in the oil on fire. The flames quickly developed into a large fire which severely damaged the wharf. The oil also inhibited the use of the claimant's slipways. It was held that damage to the wharf by the pollution of the plaintiff or the claimant slipways, it was foreseeable because damage by fire, however, was not reasonably foreseeable. So the damage by the oil was foreseeable, but the damage by fire was not reasonably foreseeable. The defendant was not liable for the fire, but liable for the pollution. Liability turned on the question of whether the risk of fire was foreseeable, since furnace oil had such a high boiling point that it was unlikely to catch fire under normal circumstances. However, it is important to note that re Polymis is not regarded as good law anymore, and a test of remoteness of damage was substituted for a direct consequences test. The test now is whether the damage of that kind was foreseeable. So, the damage of that kind being foreseeable, it must be of the same kind and of the same cause of harm. And this is a well-established rule governing remoteness of damage. The harm which is foreseeable must be of the same kind, type, and class as that which actually occurred. So long as the damage which occurs is of the same kind as that which is foreseeable, it matters not that the precise sequence of events leading to the damage was not foreseeable. So in Hughes and Lord Advocate, the defendants left a manhole in the street uncovered and protected only by a tent and paraffin lamps. The child climbed down into the hole and, as he was coming out, kicked over one of the lamps, which fell into the hole, causing an explosion by which he was burned. The lower court held that the defendants were not liable on the ground that although the injury by burning was foreseeable, as the child might easily have come into contact with one of the lamps, burning by means of this sequence of events was not. It was appealed to the House of Lords, however, which reversed the decision of the lower court, and the House of Lords held that once the type or kind of damage was foreseeable, it was irrelevant that the precise sequence of events was not. There's another principle called the eggshell skull principle, and this principle is relevant to a consideration of remoteness of damage. The principle was concisely explained as if a man is negligently run over or otherwise negligently injured in his body, it is no answer to the sufferer's claim for damages that he would have suffered less injury or no injury if he had not had unusually thin skin or an unusually weak heart. The general principle for the eggshell skull principle is that you take the tortfeasor takes his victim, as he finds him, and the victim can claim damages for the entire injury to his person, even though, because of some pre-existing condition or special physical weakness or sensitivity unknown to the tortfeasor, the harm suffered was greater than would have been suffered by a normal person. But that is the principle. So in the case of Brewster and Davis, the defendant negligently drove into the back of the plaintiff's car while the latter was waiting in a line of stationary traffic. The plaintiff suffered no apparent physical injuries, but she became anxious and nervous. At the time of the accident, the plaintiff was suffering from an autoimmune disease known as lupus nephritis, and the stress and anxiety caused by the accident exacerbated her condition, which ultimately resulted in renal failure. It was held that based on the eggshell skull principle, the defendant was liable for the consequences of the renal failure. Now there's a principle called novus actus intervenis, which means an intervening act that will break the chain of causation. And Lord Wright stated that the act must be a new cause which disturb the sequence of events, something which can be described as either unreasonable or extraneous or extrinsic. So basically the intervening act can either be one of the following: an act of nature, an act of a third party, or an act of the plaintiff. So for acts of nature, this was taken in the case of Karlslugge Steamship Company and Royal Norwegian Government, and in this case the plaintiff's vessel suffered some damage in a collision with the defendant's vessel, and this was admitted, right? Karlslugge was solely to blame. The temporary repairs were conducted, and with permanent repairs to be carried out at a different date. Right? The damaged ship was given a certificate of seaworthiness and allowed to continue to work. carried goods and whatnot. Now, during the voyage across the Atlantic, the vessel sustained heavy weather damage, which necessitated immediate repair. As a result, the vessel remained in the dry dock for 50 days, and the first 10 were allocated to repairing damage done during the collision. The plaintiff claimed damages for loss of charter hire during the 10 days attributable to the collision damage. The case was appealed and reached all the way to the House of Lords. It was held that the defendants were only liable for such loss suffered by the defendants as resulted from their wrongful act. So they could only be held liable for what they caused, not for the damage caused by the weather. Acts of a third party. In the case of Home Office and Dorset Yacht Company, where postal trainees were working on an island in a harbour in the custody and under the control of their 3 superiors. What happened was, during the night, 7 of them escaped, and it was claimed that at the time of the escape, the officers had retired to bed, leaving the trainees to do their own devices. The 7 got on board a yacht moored off the island and set it in motion, and they collided with another yacht and the property of the plaintiffs and damaged it. It was held that the fact that the immediate damage to the property of the plaintiffs was caused by the act of third persons, the trainees, did not prevent the existence of a duty on the part of the officers toward the plaintiffs, because the taking of the yacht and the damage to the other was the very kind of thing which the officers ought to have seen likely. The right of the officers to control trainees constituted a special relation which gave rise to an exception to the general rule that one person is under no duty to control another to prevent his doing damage to a third. Acts of Claimant. In McEwen, Holland, Hannon, and Curtis, the plaintiff sustained injury in the course of his employment for which the defendants were liable. As a result, on occasions, he unexpectedly lost control of his left leg, which gave way beneath him. His leg collapsed, and he made to descend some steep stairs which had no handrail. He tried to jump so that he would land in a standing position rather than falling down the stairs. On landing, he suffered severe fractures on his ankle. The question for the House of Lords was whether the act of the plaintiff broke the chain of the causation and that he jumped. It was held that the act of the plaintiff in attempting to descend the steep staircase without a handrail in the normal manner and without adult assistance when his leg had previously given way on occasion was unreasonable. Accordingly, the chain of causation was broken and the defendants were not liable for damages for a second injury. Alternatively, the plaintiff's act of jumping did not amount to reasonable human conduct. So basically what the case is saying is that it was not reasonable for him to jump, and that the fact that he did so broke the chain of causation. want to touch lightly on liability for economic loss. There must first be a distinction between pure economic loss and consequential economic loss. So pure economic loss is financial loss which is not consequent upon any physical damage to the person or property of the claimant. Consequential economic loss arises when a claimant suffers personal injuries and as a consequence is unable to work. It also refers to situations where the plaintiff's property has been damaged and as a consequence of the damaged property suffers from a fall in the value of the property or incurs costs repairing it or loss of profit from his inability to use it. Questions arise as to when a claimant can recover for economic loss caused by the defendant's negligence. As a general rule, no damage can be claimed for pure economic loss in the law of tort. Pure economic loss is a financial loss which is not consequent upon any physical damage to the person or property of the claimant. So in the case of Spartan Steel and Alloys Limited and Merton and Company Limited, the defendant negligently damaged a cable belonging to the power authority. The electric supply to the plaintiff's nearby factory was cut off. The plaintiffs lost profits arising from stoppage of steel production during the power cut. They also suffered damage to the equipment from molten metal which was in their furnace at the time. It was held that the plaintiffs could recover damages for loss caused by the molten metal but not for loss of profits otherwise. The first was consequent on physical damage to the metal, while the second was pure economic loss. The main exception to this rule of pure economic loss is negligent misstatement. It is important to note also that consequential economic loss is recoverable. Negligent misstatement. So as I stated, it is important to distinguish between pure economic loss and consequential economic loss. Consequential economic loss is recoverable and occurs in the following ways: personal injuries to the claimant for which he can recover loss of wages if he is unable to work, damage to the claimant and their property for which he may recover the repair of the property. Pure economic loss would be losses that incurred whether there is either no physical injury to the claimant or any of his property for which he suffers loss, as I mentioned earlier, or where there is a physical injury to a person other than the claimant, or damage to property belonging to someone other than the claimant for which the claimant suffers loss. So normally damages are not awarded for pure economic loss, as stated in Spartan, Steel and Merton. However, pure economic loss can be recovered for negligent misstatement, unless of course the damage is too remote. So a negligent misstatement is a statement issued carelessly by a defendant which is relied upon by the plaintiff to his detriment. So there must be a relationship. One, that's the first principle, first factor. And the major case of negligent misstatement was Headley, Bryan and Heller partners. So in the case of Headley, Bryan and Heller partners, the facts of the case are that Headley, Bryan were advertising agents placing contracts on behalf of a client on credit terms. Hedley Bryan would be personally liable should the client default. So to protect themselves, Hedley Bryan asked their bankers to obtain a credit reference from Heller Partners, the client's bankers. The reference was given both in orally and in writing, and were very favorable, but also contained an exclusion clause to the effect that the information was given without responsibility on the part of the bank or its officials. Hedley Bryan relied on this reference and subsequently suffered financial loss when the client went into liquidation. The court found that the disclaimer was sufficient to protect Hedley Bryan to protect Heller Partners from liability. The House of Lords, however, ruled that damage for pure economic loss could arise in situations where the following conditions were met: where there was a fiduciary duty of trust and confidence existing between the parties, where the party preparing the advice and information voluntarily assumed the risk, where there had been reliance on the advice or the info of the other party, and such reliance was reasonable in the circumstances. But on the topic of negligent misstatement, the court essentially ruled that there must be a close relationship in order to succeed in a claim for negligent misstatement. So the representations have to be made by the defendant. So if the information supplied by the defendant is not in the form of a representation, then the claim will not succeed. So, in the case of Anderson and Sons and Rhodes, here the parties were dealers in a fruit market. The plaintiff inquired of the defendant as to the creditworthiness of a newcomer, and he told him, yeah, they're alright. In fact, the newcomer owed thousands of pounds to the representer's firm, but due to the negligence of the accounting department, this was unknown. It was held that a special relationship, as required by the case of Hedley Bryan and Heller Partners, that it existed. And when they quoted the statement as the person being alright, there was a representation that was made, and the defendant was therefore liable for the loss. There must also be reliance on the statement made by the plaintiff, statement made by the defendant, and the defendant must be aware that the plaintiff is going to rely on this statement. In the case of Smith and Eric Bush, the plaintiff had applied to a building society for a mortgage and was required to pay for a valuation to be done on the property by the defendant. The report overvalued the property, and the valuation contained a disclaimer that the defendant would not be liable in the event of any negligence. It was held that the disclaimer failed the test for reasonableness, and as such the defendant was held to be liable. Finally, defenses for negligence. So one of the main defenses are contributory negligence. Contributory negligence is basically carelessness on the part of the claimant which combines with the defendant's negligence or breach of duty in bringing about the claimant's damage. So I'll give you some cases. In the case of Bailey and Gore Bros Limited, plaintiff was employed by the defendant in the operation of a stone crushing machine. The machine was defective, and while working, a bolt frequently slipped, causing the rollers to become choked and to stop. The operator would then climb up to the machine, clear the stones from the rollers before the machine was started up again. One day, the appellant, having cleared the choke, was climbing down to the ground while the rollers were working. He slipped and fell. His right hand was caught between the rollers, which was not protected by any guard. He was severely injured. He claimed damages for failure to provide a safe system of work. The respondents pleaded contributory negligence. The court held that the respondents were liable to the appellant in negligence, but the amount of damages would be reduced by 10% on account of his contributory negligence. In the case of Guinness and Ramdale, plaintiff and the defendant had indulged in a 3-hour drinking session. They set off in the defendant's car with the defendant driving. The defendant lost control of the vehicle, which crashed into a wall, causing injury to the plaintiff. It was held that the plaintiff had been contributory negligent in remaining in the car when he knew the defendant was unfit to drive. The plaintiff's damages were reduced by 20%. In the case of Wood and Francis, a motorist was killed in a collision caused solely by the defendant's negligence. The deceased was not wearing a seatbelt at the time, and such wearing was not compulsory. The court found that it was more likely than not that the accident would have killed the deceased even if he had been wearing a seatbelt. It was not therefore a case where the deceased could have been held guilty of contributory negligence. As mentioned many times, standard of care is a consideration when dealing with negligence. And the standard of care for a person's safety is expected. It is expected that the standard of care for his own safety expected of a claimant is that of a reasonable, prudent person. However, in the cases of children and workmen, a lower standard is accepted. So for children, in the case of Yachuk and Blyth, the defendant sold some gasoline to a 9-year-old boy after being told by the boy that his mother wanted it for her car. The boy played with it and was badly hurt. It was held that the defendant was fully liable for the injury. He had been negligent in supplying gasoline to so young a child, and the child was not guilty of contributory negligence, for he did not know and could not be expected to know of the inflammable properties of gasoline. In Peach and Transport Board, the plaintiff was a 12-year-old schoolgirl. She was seriously injured while attempting to board one of the defendant's buses outside the school which she attended. The defendants pleaded contributory negligence, and the court held that the accident was caused by negligence of the driver in failing to stop immediately when school children tried to board the bus while it was in motion. Damages were reduced by 20% due to the plaintiff's contributory negligence, however. Second defense, voluntary non-fit injury. So this means, as mentioned before, it essentially means that if you consent to something, there is no legal damage. And I'll explain. So generally, no one can enforce a right which he has voluntarily waived or abandoned. So consent is a defense to intentional torts, such as assault, battery, and false imprisonment. It may also be pleaded in negligent actions as well, as in most other torts. So if you consent to something being done to you, then the general principle is that you can't enforce your right to have it not done to you if you consent to it being done to you. So the voluntary nature of the tort or the defense can be established in three ways. One, the first would be by proof of an express contract. So where the claimant expressly agrees to exempt the defendant from legal responsibility, the defendant cannot be held liable. The second is where it can be proven that even though there was no express contract, that there was express consent around the risk. So in the case of Morris and Murray, two men had a heavy drinking session and then took a light aircraft for flight. It ended in a tragedy where the defendant pilot was killed and the claimant was significantly injured shortly after takeoff. It was held that the pilot was obviously intoxicated and as such unable to exercise care, that the claimant must have consented to the risk. He could see that he was intoxicated, they were both drinking, and he must have been able to consent to the risk that this might happen, this might be a result. And thirdly, even where there is no express contract or no express consent, it may be showed that it must be further implied from the fact that the claimant consented to run the risk. So, like generally for sporting events, the defense of voluntary non-fit injury has not found great success because it is assumed that the person participating in the event consents to the possibility of the risk happening. So in a game like rugby, American football, regular football or soccer, where collision is part of the game and injury is part of the game, it is presumed that you consent to such injury being done to you, or the possibility of such injury being done to you. And so that is all I have to say on the law of negligence. This has been a very long video, and it has also been disjointed in many parts, but I hope it is of some use to you, and I will see you in the next video. Take care.